I can hear you. Can you hear me?
Yes, we can hear you.
Okay.
Okay, students, I'm going to hand over now to Mulebogeng, who will be doing today's session. Mulebogeng, you can take over.
All right. Thank you very much. Good morning, ladies and gentlemen. My name is Mulebogeng, and I'm your lecturer for Family Law, PVL2601. So, can I have the opportunity to set out the house rules for this session? We will be having students kindly set your mics off and your cameras off too. So I will be presenting this study unit 2. So throughout the session, should you have a question on a particular a session that I will be talking on, kindly write down or note down a question that you want to ask on that particular part, and then we will be taking questions at the end of the session. This is to allow us to spare time and then prepare all of you to have time to ask the questions at the end of the session. It's that understood. All right, thank you very much. Okay. In the previous study unit, we learned about the legal requirements for a valid marriage. And in that session, we learned how there could be a non-compliance to certain legal requirements to a marriage, which renders the marriage void, and that the non-compliance with a legal marriage also renders a marriage non-voidable. Okay, so in this study unit, we will be focusing on marriages that are civil marriages that are void, civil marriages that are voidable, and putative civil marriages. A void civil marriage is a marriage, it means that the marriage can never come into existence. There are grounds that serve to the nullity of the marriage, which can be done either by the court on the grounds that the non-compliance with formal or material requirements for a civil marriage have not come into being. We have a case law which was one of the grounds of nullity of that rendered a marriage void. In ex parte, the solemnization of the civil marriage in a garden instead of a church or other building used for religious purposes, or a public office or a private dwelling house with open doors also does not render the marriage void. Okay, in this case, it was one of the grounds that illustrated that the non-compliance in this regard of a formal material marriage was not void. Okay, so there are examples. I'll share examples of non-compliance with formal requirements, okay, which render a marriage null. A civil marriage solemnized by someone who is not a competent marriage officer, a girl below the age of 15 years, or a boy below the age of 18 years entering into a civil marriage without having obtained the written consent from a minister of Home Affairs. Thirdly, it is the absence of the witness at the civil marriage. The second example that I will be sharing of non-compliance will be of the material requirements, where the parties are of the same sex. Remember, we did mention that in the previous study unit that a civil marriage is a marriage of it's a monogamous marriage. Okay, so it is a marriage of two opposite sex. So in this case, the marriage will of non-compliance with the material requirements, it's due to parties who are of the same sex. So the second example is one party where one of the parties is already a party into another civil marriage or customary marriage, a civil union, marriage with someone else. And then the third example is where parties are related to each other within the prohibited degree of a relationship. The next example is where a party is below puberty. And the last example is where a party is mentally ill. Remember, these are some of the prohibited relationships, and where one is not qualified, where the capacity to act as a party to a civil marriage. So there are consequences of a void marriage. Void marriage does not affect the status of a party as a void marriage does to confer any of the consequences of a marriage on the parties or their children. No matrimonial property system is operated between the parties. No reciprocal duty of support between the parties. Parties may not inherit interstate from each other. The parties' children are children born of unmarried parents. The nullity of the marriage is absolute. So either of the parties or the interested third party may raise a claim, and may also be raised often after the death of the parties. Please note that a bona fide party to a void marriage may institute intellectual action for satisfaction against the other party to the void civil marriage. Okay, so I will be moving to voidable civil marriages. These are marriages where the grounds are present either before or at the time of the wedding, on the basis of which the court can request to set aside the marriage. So I'm going to give you the grounds of setting aside a voidable civil marriage, okay, where one or more circumstances can be present. Where there is a minority, meaning that the parties are of minors, and then the mistake of where it excludes consensus between the parties. Remember, one of the legal requirements to a civil marriage involves the consensus agreement of both parties into the marriage. So duress, where one is forced into the marriage, and undue influence. Subram, it's where a wife had an extramarital intercourse with a third party before the marriage, and then she gets pregnant, and the husband is unaware of the pregnancy during their marriage. So such a husband can apply for the marriage to be annulled. So the other ground to set aside a voidable civil marriage is impotence. This is where a party, one of the parties in the marriage, is unable to have intercourse with the other party, and where the other party is unaware of the inability of the person to have intercourse with them at the time of the wedding. So sterility, which is infertility, meaning unable to procreate. So the consequences of a voidable civil marriage is where a voidable marriage It remains in force until it is set aside by a court order, which means the court has to give out the order so that the marriage may be set aside. Secondly, if the marriage is set aside, the effect of the decree of an annulment is retroactive. And then the status of the parties changes and in the position as if the marriage never took place. So the third parties are then protected because of the validity of the transaction before the annulment. Excuse me. So children born of the voidable marriage, which is annulled, are treated like children whose parents' valid marriage is terminated by divorce. So we will be moving to the third marriage, the third type of marriage, which is a putative marriage. This marriage is where one of the parties or both of them enter into a civil marriage while being unaware that there is a defect which renders the marriage void. So in this case, the parties have entered into the marriage and are unaware of the defects that might render the marriage void. Let me give you an example. Where the couple enters into a civil marriage without being aware that they are related within the prohibited degree of relationship, the degree of blood relationship. They can either be half brothers and sisters or biological, like full brother and sister. So the requirements to a putative marriage are of where one of the parties or both of them must be unaware of the defect which renders the marriage void, which is basically what the definition of the putative marriage is. And at common law, it requires that all formalities for the solemnization of the civil marriage had to be complied with. So common law requires that all the requirements, all the formalities need to be present for the marriage to be valid. And the consequences of a putative marriage, it is void ab initio. It has the legal consequences of a valid civil marriage as long as at least one of the parties had a good intention, which means they were aware of they were unaware of the defect. It can either be one of the party or both of them. So that will render the marriage void. So children born of a putative marriage, according to common law, are born of married parents. So there are patrimonial consequences of a putative marriage. So if both parties had good intentions when entering into the marriage without an antenuptial contract, they are considered as having a joint estate, indicating that the marriage is in community of property or having concluded an universal partnership. This will be a universal partnership will be discussed in the later stage of our sessions. I think, yes, that will be touched on at the end of our session. Okay, so this is my presentation of study unit 2. Let me see if any of you have questions that we can answer. Ladies and gentlemen, any questions? Please, by a raise of hands.
Okay, Jonia has raised his hand. Jonia, you can unmute yourself. Jonia, okay.
Good morning to everyone. I want to ask on G. I think it's G. Under voidable civil marriages. I just want clarity. I don't understand.
Okay.
Clarity.
When you say you don't understand, what is it that you don't understand the difference between void and voidable, or what? When you say
No,
No.
on
the
G.
textbook. You mean in the textbook, right?
Yes,
on
the
page
textbook.
36.
On page yes, on page 36.
All right, okay. Let me try to, let me answer that. Okay.
Clarity.
The clarity on only that part.
Yeah.
Okay. So you understand that what a voidable marriage is?
A voidable marriage is
Okay, I just want I want to actually link everything to you so that you have an idea of what's happening here, ne? Okay. G nest being it's sterility, ne? Sterility means this person is infertile. They are unable to procreate, meaning they cannot have kids. So when one doesn't disclose that, or maybe it's unaware of such a situation, and this person wants to enters into the marriage with the idea of procreating, that can be used as a ground to set aside the marriage to be voidable.
okay.
Yes, it is said to be a ground that allows one to use to set aside a marriage to be voidable. Meaning, if one cannot, if say for example the two parties are in this marriage, and then the other party cannot procreate, is infertile. Yes, that can be used as a ground to set aside the marriage as voidable.
Oh, okay.
Am I clear? Is that clear?
Yeah, it is.
Okay.
Okay, Tepiso, you can unmute yourself. Jonia, please mute yourself. And Tepiso, you can unmute yourself. Tepiso, you can ask your question. Tepiso, please unmute yourself. Tepiso, we can see your hand, so please unmute yourself and ask your question. Okay, Muleboge?
Yes.
Okay, I don't know, you can see on under putative marriages, there is a case there, Zulu versus Zulu.
Yes.
Okay, can you just briefly tell them what they thought on Zulu versus Zulu, because there have been some legal development which I just want to share with the students. But before I share that legal development, they firstly need to understand what was said in Zulu versus Zulu, because it is one of the leading cases under putative marriage.
Okay. Student, do any of you have your textbook with you? Okay, let me just check. All right, I'm going to read out the decision in Zulu versus Zulu. Well, in this case, remember that this case is under putative marriage. So in this case, the rules did not apply in the putative marriage was concluded while either of the parties was in an existing valid marriage in community of property. The court held that in such an event, the pre-existing of the valid civil marriage in community of property renders creation of joint estates between the parties to a putative marriage impossible, because all assets of the parties who is the spouse in the valid civil marriage fall into a joint. Remember, we did mention that when they do get married, their assets under patrimonial consequences, their assets are placed into a joint estate where they enter into a marriage without an antenuptial contract. Their property is considered being in a joint estate, indicating that they will be in a community of property marriage. So their assets of the parties fall into a joint estate which exists between the spouses in a pre-existing valid marriage. So if parties enter into a marriage with in this case where they conclude a antenuptial contract in which the community of property was excluded, the marriage is then treated as having been out of community of property. If this is the interest of the bona fide, with the one with good intention, or both parties were bona fide, this will be in the interest of a party with good intentions. Yes.
Okay, thank you. Basically, in short, in the Zulu versus Zulu case, which the decision was made in the year 2008, it was held that if parties are married, are in a civil marriage, a putative marriage cannot be in community of property if either of the parties is a spouse in an existing civil marriage which is in community of property. So the legal development is that earlier this year, the Free State High Court, the Free State Division of the High Court, made a ruling which actually went against what was said in the Zulu versus Zulu case. So what happened in this case, the citation of this case is MS versus Executor Estate Late NS. What happened in this case is that the applicant, okay, let me just summarize it like this. There's the applicant who is the surviving wife of the deceased husband. The deceased husband entered into a civil marriage with the first wife, and they got married, but after a period of after 3 years, they separated without formally terminating their marriage. After they separated, the deceased husband then went on, entered into a relationship with the applicant in this new case, and then they entered into a civil marriage, and they lived together for a period of plus minus over 20 years or so, up until the husband passed away, the deceased. After the husband passed away, the applicant went to the master of the High Court to go and report the deceased estate. When somebody dies, after they've been buried, we need to go and report their death at the master of the High Court so that they can issue the letter of executorship. when the applicant went to the Master of the High Court, it was only then that she learned that the deceased husband was still legally married to the first wife. So she brought in an application to the High Court whereby she requested that her marriage be declared as a putative marriage and that she be given 50% of the house that she and the deceased husband had. The court held that although the deceased was still legally married to the first wife, in essence, their marriage ended when the two of them separated, and there was also no proof that they actually acquired assets in the joint estate. The only thing that rendered the deceased and the first wife being married is that they have a marriage certificate, if I can call it that way. The court held that putative marriage should be applicable even if the parties are in a civil marriage and the marriage is in community of property. The result is that although the deceased was still legally married to the first wife, the second wife, although the marriage is void because they can never be two civil marriages at the same time, her marriage was declared as putative, and the court ordered that she be entitled to inherit 50% of the joint estate. So this judgment goes against what was said in the Zulu versus Zulu case, where they said that if the parties are in a civil marriage and their marriage is in community of property, then the subsequent wife is not entitled to a share of the joint estate. In the latter case, the court has held that the subsequent wife is entitled to 50% of the joint estate, although her marriage was in community, was in civil marriage, though that civil marriage is null and void. So, student, do you understand now? Because this is a huge and a big development. Basically, it means that, let's say there's John who is married under a civil marriage, and then John and the wife, the first wife, just decide to terminate their marriage, but without filing for divorce, they just separate, and then John goes and marries another woman. But in terms of the law, that marriage is null and void because he is still legally married to the first wife. So the second wife, if she can prove that she entered into the second marriage without being aware that the husband is not legally divorced from the first wife, and that she contributed everything while living with the husband, there is now a possibility that the court can declare that yes, your marriage is putative, and then yes, you are entitled to 50% of the joint estate, even though your marriage it is null and void. This was a decision from the Free State High Court, and now we are awaiting for the matter to be referred to the Constitutional Court for confirmation that indeed the subsequent wife whose marriage is null and void has a right to inherit 50% from the joint estate. Does anybody have any question regarding a putative marriage and then this legal development, which is actually going to affect a whole lot of people. I'm saying it's going to affect a whole lot of people because we are aware that we live in a society whereby there is quite a high number of married spouses who are actually separated, who have moved on with their lives, and who are in cohabitation relationships, or who have married new spouses, others, whether through civil marriage, even though they have not registered their marriage with the Department of Home Affairs, or they entered into a customary marriage, but they are still legally married to their first spouses. Does anybody have a question? Okay, Mukhadi, I can see your hand. Mukhadi, please unmute yourself.
Okay, I have done. Thank you, and a very good morning to you all.
Morning.
My question is: once one gets into a civil marriage, does it automatically mean that they are married in community of property, or they can choose to be in community of property or out of community of property?
Okay, we are going to have a session on matrimonial property regimes, but to answer your question, all marriages are in community of property by default. If prospective spouses do not want to get married into a community of property, they need to sign an antenuptial contract before entering into a marriage. So engaged couples need to go and get proper legal advice as to the different types of marriage contracts that they can enter into. If they don't do that, and then let's say they just go to Home Affairs and sign the marriage certificate, the marriage register, or after their wedding ceremony, they sign the marriage register with the pastor or with the marriage officer, their marriage will automatically be in community of property.
All right, understood. Thank you.
Okay, thank you. Johanna, again, Jonia Relewuhile, unmute yourself, please.
Can I ask if somebody marries in a legal way, first wife is in a legal way, and then he goes and marries or takes out lobola for maybe 3 women without them knowing. Is that a putative marriage?
Okay, the first question will be, is the first marriage under civil law, or are all these marriages under customary law? We are
It's
also
civil.
going to, okay,
The first one it's civil,
a civil
and
marriage,
then
okay, a civil marriage is monogamous. So if spouses are married under a civil law, subsequent marriages are null and void, because you cannot be in a civil marriage and also be in a customary marriage. Hence, we also have different legislations that regulate different marriages. We have 3 types of marriages in South Africa which are currently legally recognized. Again, we will have a session on this. But just to answer your questions, we've got the Marriage Act, which legally regulates civil marriages. And then we've got customary recognitions of customary marriages act, which regulates customary marriages. And then we've got the Civil Union Act, which regulates civil unions, same-sex marriages, or those of the opposite, like the heterosexuals, couples, but who choose to enter into a marriage under the Civil Union Act. So if you are in a civil marriage, your marriage must follow the requirements under the Marriage Act. And one of the laws is civil marriages are automatically, they are monogamous. So once you are in a civil marriage, it does not matter how many women you have lobolati, it does not matter that you celebrated the customary marriage. Those marriages are going to be void because they are not in line with what the law says. So only the first marriage is legally recognized. Others are what I say, they are celebrated girlfriends. Celebrated girlfriends in the sense that they paid lobola for you, there was a celebration, but in the eyes of the law, you are nothing but still a girlfriend. That's okay. Thank Tepiso? Tepiso?
Thank you so much, ma'am. Can you hear me?
Yes, we can hear you, Tepiso.
Yeah, the last time I raised my hand, I couldn't unmute my mic.
Okay.
I have a question under the grounds of nullity. I don't know if I'm pronouncing that correctly. Number three, not number three, number two, in the textbook, page 33, it says a girl below 15 years of age or a boy below 18 years of age enters into a marriage, blah, blah, blah. So I want to know if a girl maybe is 16 years old and then a boy is maybe 19. Is the marriage not null or something?
Okay, you say it's on Mulebchen?
Yes, thank you for
Okay.
your question. Yes, on page, yes, that's exactly what you mean. It means that if a girl is 16, remember in this example of the formal requirements, it states that a girl below the age of 15, so which means when they are 16, that consent is not as much necessary or required as it would be a girl under the age of 15.
All right, thank you so much.
Yes, you were very much welcome.
Okay, students, do we have any other students who would like to ask any questions, any comments? Please feel free to ask or feel free to say anything. This is your opportunity. We are not seeing any hands, so our assumption is going to be that you understand everything. Okay, students, if you're not going to have any questions, we are going to end these sessions here. But feel free to send us an email if there is something that you want clarification on, or maybe if you were just shy to ask in front of other students. Yeah? Please feel free to send us any questions. Tepiso, I can see your hand. Please unmute yourself and ask your question.
Yes, I'd like to know something. If let's say the husband wants a divorce, ne? And then the wife doesn't want a divorce, and then they separate, and then now the man marries in customary with another woman. Does that make the marriage putative or what?
Is void. If
It's
the
void.
husband is in a civil marriage, remember, civil marriage is monogamous, meaning that it's one man, one woman only. So even if they can separate for a long time, it's going to be a null and void because it is under customary marriage. When we get to talk about customary marriages, you'll understand that under customary marriages, they don't recognize putative marriage. The only difference will be if the husband had entered into a civil marriage, which in today's time is going to be extremely difficult because one of the requirements of the civil marriage is that after solemnization of the marriage, the parties have to sign the marriage register, and the Department of Home Affairs will issue them with a marriage certificate. So the Department of Home Affairs issues, when it registers the civil marriage, is one couple at a time. When the subsequent couple, let's say the husband with the second lady, Home Affairs will not be able to register that marriage because on the system there's already an existing marriage certificate. But
And then
okay.
And then does that mean if, let's say, maybe then the man passes away, and then what happens to his estate?
Okay, when death occurs, the rules
Yes.
change slightly. Firstly, let's say there was a pension. There is a law that regulates the rules around pension. So, for example, the Pension Act has a section called Section 37C, which says trustees, you have the right to have the final say as to how you're going to distribute the pension of the deceased. So the girlfriend or anybody who was financially dependent on the deceased has a right to lodge in a claim. So it has happened many times that the pension trustees have distributed money in equal share, the pension money in equal share, to the wife, the surviving spouse, and the existing lover. This is because of the Pension Act. So the marriage certificate or the validity of the marriage, it was really irrelevant at that time, because it does not matter whether you are married or not. The question is, in terms of Section 37C, do the trustees, after all the determination and the investigation, have they ruled that you indeed are actually entitled to something? And then when it comes to the estate, which is your monies, your businesses, your houses, and everything that is under your estate, then it's going to depend on whether there is a will or not. If the parties are married in community of property, a spouse who's married in community of property has a right to leave a will and say, I want this to happen to my 50% share of the joint estate. So you can be married in community of property, but your spouse can write a will and exclude you from inheritance and include their lover. Understand?
All right.
So hence
Okay.
it changed. And I just want to say that although I keep on saying the example, a husband is the one who's getting married to this and this, the situation can be opposite. It can happen that it is the woman who left the husband and goes and gets married to somebody else, even though that marriage will be void. Understand that? So when I keep on saying the husband, this, the wife, it's just an example, but just know that what applies on the left for the woman also applies for men as well.
Thank you so much.
Okay, thank you. Jonia, Relebogile?
Ma'am, I just wanted to ask, the coming assignment will be based on which chapters?
Okay, unfortunately, I cannot answer that. As you are aware that our systems are down, so I can't remember the questions and everything, but it's gonna be on the modules that we, the sections that we actually are busy studying on. That's all I can say now. But for specifically concentrate on this section or what, honestly, I really cannot remember.
Okay.
Okay, I'm sorry about that. Mukhadi?
Thank you. I am not sure if I have heard you right, but I heard that you said a husband and a wife can be married in a civil marriage and also in a community of property, and also one can leave a will behind. Doesn't it contradict? Because I get it when it says in community of property, then it means it's a 50-50 share, 50%, 50% share. So if one leaves a will behind and then exclude the wife, doesn't it contradict?
Okay, firstly, let me explain how this works. We've got the marriage type that you are entering into, and we've got the marriage contract. These are two separate things and are regulated by two separate legislation. When you get married under civil marriage, you have to comply with the requirements as per the Marriage Act. And when it comes to the marriage type, which is in community, out of community of property, that is regulated by the Matrimonial Property Act. So you can get married under civil marriage. That is the type of marriage. Now, when it comes to the contract, you are married in community of property. In community of property means we have one joint estate. we've got this house, 50% of this house is yours, 50% of the other section, 50% belongs to your husband. So although you have one joint estate and there's this house that you both own, as a wife, you have a right to say, with my 50%, I want to leave it to my children. So you have a right to do whatever you want with your 50%, but you cannot say, for example, in your will, I leave this house to my children because you only own 50%. So it is not contradicting, because although what is yours is mine, what is mine is yours. In reality, we only own 50%, 50%, and each spouse is allowed to do whatever they want with their 50% share in the joint estate. But here we are talking about death when you live in a will. But while we are still alive, you hear when we talk about the implications when you are married in community of property. There are situations whereby you cannot take or enter into certain transaction without firstly getting the consent of your spouse, but there are certain transactions that you can enter into without getting the consent of your spouse. But when it comes to drafting of the will and leaving your inheritance, you are allowed as a spouse in a joint estate to decide what must happen to your 50%, and you are not legally obliged to leave your spouse anything.
Okay, understood. One more question. Let's say we are married and then within a month or so we decide to divorce. Are there no laws that can be, let me say, maybe I came to the marriage with nothing, and then my husband has everything that we have now is of my husband, and then within a month or so I decide that I want to divorce. Would I still get that 50%, or there are laws that are saying, putting a time frame to it?
Okay, we are going to talk about termination of a marriage through divorce. But to answer your question, we have what we call forfeiture of benefit. Forfeiture of benefit is when you ask the court that I want my spouse to forfeit a certain share or all the shares from my 50% of the estate because of this certain conduct. There are requirements that firstly must be complied with. So if you get married and within a month you want to file for divorce, on a principle of it, you are entitled to 50%, but your spouse can ask the court for forfeiture of benefit. If they are successful in their forfeiture claim, then you are not going to get from the joint estate.
All right, understood. Thank you.
Okay, thank you. Angelique, please unmute yourself.
Yes, good morning.
Morning.
Yes, I would just like to know if you are able to provide me with examples of a putative marriage.
Putative marriage, let me use the example of the recent Free State High Court judgment, where the husband is legally and in a civil marriage with the first wife, but they separated without getting a divorce decree. They just separated, and the husband, who is now deceased, went and got married to another woman, civil marriage, and they continued to live together for many years up until he passes away. So the difference with this case is that many years ago, before we had before the democracy, black people, I think when they entered into marriages, their marriage certificate were not really recorded at the Department of Home Affairs. So it was easy for a spouse to just simply leave this one and go and get married to another one, because both these women have a civil marriage certificate. But because the law says a civil marriage is monogamous, so only the first wife was legally recognized. So a putative marriage is under these circumstances where there is this man who entered into a civil marriage with both these women. And we know that one of them is null and void, but their relationship was such that it was a marriage. It was a marriage. But for the husband not divorcing the first wife, the second one's marriage was going to be declared a legally recognized marriage. And the second wife was able to prove that I entered into this marriage with my husband and beware that you are still legally married. So I am also an innocent victim into this whole thing. So that is an example of a putative marriage under the civil, where both parties are in a civil marriage. The situation becomes a bit tricky where the other spouse is entered into a marriage, but their marriage is a customary marriage. The law is clear, and the Constitutional Court and the Supreme Court of Appeal have already ruled that a spouse cannot be in a civil marriage and a customary marriage. So it happens in many marriages that the first marriage will be a legally valid unregistered customary marriage, and the spouse, they will just separate, and the other one will enter into a civil marriage where they'll go to Home Affairs and get the marriage certificate. So because the Constitutional Court have already confirmed that this type of marriage, it is null and void, and also to date we do not have a court judgment which says this kind of marriages where one marriage is under the civil marriage recognized by the Marriage Act and the other one is under a customary marriage and it is regulated by the Recognition of Customary Marriages Act. We do not have a precedent which says this type of marriages can also be regarded as a putative marriage. We have a judgment, though not from the Supreme Court of Appeal or the Constitutional Court, where this judgment says a putative marriage cannot be, you cannot find a putative marriage if the marriage is under customary marriage. To understand, I'm not sure if I was able to explain it to you. So it is a bit tricky now because the society that we live in now, we are seeing a high number of marriages where one is civil, one is customary marriages, and then on the principle of it, if one innocently enters into a marriage without knowing that their spouse is in a legally recognized marriage, especially if the first marriage is an unregistered customary marriage, and then the subsequent wife is very innocent after doing their due diligence, checking with Home Affairs, and they find out that, my partner is indeed single. And after many years or when death occurs, then they subsequently discovers that, but this partner or this spouse of mine is actually or was actually in a legally recognized marriage, meaning that my marriage is null and void. So on a principle or on the face of it, you can say, but that is a putative marriage. So the only thing that is making it not to be a putative marriage is this court judgment that says in a customary marriage, you cannot find a putative marriage. But we are going to talk about this in detail when we talk about customary marriage. For now, under civil marriages, you can find a putative marriage as long as both marriages were entered into in terms of the Marriage Act.
All right. Thank you so much.
Okay, thank you. Students, do we still have any other questions? Students? Okay, thank you for joining today's session. And again, let me apologize for the technicalities that we are having with the model system, the my models system. We are hoping that at least by before the end of this week, everything would have been sorted out and things are going to get back to normal. We shall meet next week again when we tackle another section. Please be on the lookout for the announcement for the topic that we'll be talking about next week, and also for the link to join the session. And this session was recorded, and as soon as the recording is available, we are going to upload it on the we have created the YouTube channel, so we are going to upload it on our YouTube channel, and yes, we'll send it also on the announcement so that you are able to access the YouTube channel. Thank you very much, and we shall see each other next week. Goodbye.
Goodbye.